Adjustment of status. Okay, in this video I'll talk about how you can adjust your status to a green card status using the form I-360. This form is sometimes overlooked, but it has a lot of great information. If you qualify, then you can go ahead and use this form and apply to actually get it approved. Then you can later on adjust your status to a green card status. Okay, let's get right into it. So let's start with the first thing. It has at least what I call three main options where you can use this form to adjust your status. So the first option is for an immigration, and then the second option is for a widow or widower of a U.S. citizen, and then we have a third option for special immigrant. And within the third option, you see there are a lot of people that could qualify as special immigrants. So I am going to go over the requirements just the way it is listed on this form, so that you can be able to see if you qualify, then you can go ahead and apply. Okay, let's start with the first one. Immigration. It clearly says if you are 18 years old, basically 18 years old of age or older, you might file this petition for a beneficiary, including yourself, who was born in Korea, Vietnam, Laos, Cambodia, and Thailand after December 31st, 1950 and before October 22nd, 1982. And you see there is another requirement to it, and was fathered by a U.S. citizen. And then it says that a U.S. corporation may also file this petition for a beneficiary. Okay, so this is basically, you know how you have to be 21 years old in order to actually file a petition for someone, but with this one you only need to be 18 years old of age. That's the minimum age requirement, but still you must have been the person that you are filing a petition for must have been fathered by a U.S. citizen. Okay, meet those two requirements, and then you go with the place that you were born. Okay, so and that's the requirement for immigration. So let's go with the second requirement, and then it lists all the evidence that you should provide right here. I'm not going to go into it. I'm just talking about the basic requirements. Okay, the second requirement is for widow or widower of a U.S. citizen. Okay, for this one, remember when we said that sometimes the how do we say it, the petition dies with the petitioner, but in this specific case the petition does not die with the petitioner. So the petitioner might pass away, but if the petitioner was a U.S. citizen at the time of death and you were married to them, you can also claim your benefits through that. Okay, and those are the requirements. It says you were married to a U.S. citizen who is now deceased and who was a U.S. citizen at the time of the death. Okay, your U.S. citizen spouse died less than 2 years before the date on which you filed this petition. Okay, you are not legally separated from the U.S. citizen spouse at the time of his death, and you might have not remarried. So you pretty much have to meet all those 4 requirements in order for you to file this petition. Okay, and this is really crucial because some people sometimes we think that the petitioner dies with the petition, but in this case, specific case, you might still have a chance to file for this petition and later on adjust your status. Okay, so those are the 4 requirements that you must meet. And Now we go into the third category, the special immigrant category. And in the special immigrant category, there are a lot of people that can be qualified as special immigrant. And the first one is special immigrant juvenile. And then the qualification, very simple. You must be present in the United States. You must be unmarried and less than 21 years of age. Okay. And then you have been declared dependent upon a juvenile court in the United States, or who such a court has legally committed to or placed under the custody of an agency or Department of State, or an individual or entity appointed by a state or juvenile court. So, and then it says has been subject of a determination by juvenile courts. So basically, you have to be determined. It has to be set in the court that you're dependent. Perhaps you have been abused or something happened, but under the court order, you have been declared independent or dependent. For that matter, declared dependent by court, and that's when you will qualify to file under this special immigrant juvenile category. Okay, pretty much you meet those 5 requirements. And then the last one is that has been the subject of administrative or judicial proceedings that determine that it will not be in the juvenile best interest to return to the juvenile of their parents' country of citizenship. Okay, this really applies a lot to, remember, people who actually get in the US prior to turning 21, and younger people who come to the US prior to turning 21 and without parents, and finally they get a court order declaring themselves dependent, and then and placed under the custody of some type of agency or Department of State. Those individuals have better chance to actually file this petition and get it resolved. Okay, and then later on adjust status to a green card status. Remember, we are still trying to get you a green card, but one way or another, legal means available to us, we will do it. That's why I just thought about this form, because this form is really overlooked, because a lot of people, when they think about this form I-360, all they think about is VAWA petition. Okay, the VAWA petition is included in this form I-360, but there are a lot of things that you can, if you qualify, of course, can benefit from it. Okay, so let's move on to this other special immigrant category. This one is for special immigrant religious worker. Okay, for this one, it says really a U.S. employer may file a petition for a beneficiary who seeks to enter the U.S. to be employed full-time by a bona fide non-profit religious organization in the United States. Okay, solely as a minister of that religious denomination, okay, in a religious vocation, either in a professional or non-professional capacity. This is very important. It doesn't have to be your profession to be a minister, but you can work in a professional capacity or non-professional capacity. Okay, in a religious occupation, either in a professional or non-professional capacity. So basically, this one is the church as the one that can file for you this religious worker, special immigrant religious worker petition, and then they have to file for you the form I-360, and they have to have those other requirements met as well. You have to meet those requirements, and then it says to qualify, the beneficiary must have been a member of a religious denomination that has a bona fide non-profit religious organization in the United States for at least 2 years immediately preceding the filing of the petition, and working continuously after turning 14 years of age in one of the positions described above, either abroad or in the United States, at least 2 years immediately preceding the filing of the petition. Okay, so basically this one, the church or any type of religious organization will file this petition for you, and when you come here, you're working solely as a minister of that religious denomination. Okay, either in a professional capacity or non-professional capacity. Either it's a vocation or it's just some type of occupation, and then maybe you started working of let's say the church, that religious organization has an extension in your home country. Maybe you started working there already, or here you've been working at least for 2 years after filing for the petition. You start working there for at least 2 years preceding, before filing the petition, you were working there for 2 years. Okay, yeah, you have to really make sure that you meet that part as well, because it's 2-part test: the work that you're doing here, and then this requirement and this requirement. And that is something that the religious organization has to file for you, not yourself. Okay, and then you have evidence that you have to submit along with this organization. Okay, so once we move, we go to the other one is special immigrant based on employment with the Panama Canal Company, Canal Zone Government, or U.S. government in the Canal Zone. Okay, and this one, it has its requirement as well. It says that you might file the petition for a beneficiary who, at the time the Panama Canal Treaty of 1977 entered into force, you were a resident in the Canal Zone and have been employed by Panama Canal Company or Canal Zone Government for at least 1 year. You were working there for, you have to be able to prove it as well. And then, or a Panamanian national, either honorarily retired from U.S. government employment in the Canal Zone with a total of 15 or more years of faithful service. Or, so either this one, or this one, employed for 15 years and been working for at least 5 years, and whose personal safety or the personal safety of his spouse or child is in danger as a direct result of the special nature of his or her employment, as a direct result of the treaty. So basically, this is very specific to whether you work there, and you have to meet as well those 3, not all of those 3 requirements, but at least one of them. Okay, and submit proof. Then we have a special immigrant physician. Okay, you might file this petition for a beneficiary who graduated from a medical school or is qualified to practice medicine in a foreign state, was fully and permanently licensed to practice medicine in the United States on January 9, 1978, and was practicing medicine in the U.S. state on that date. Enter the United States as an H or J non-immigrant before January 9, 1978, and has been continuously present in the United States and continuously engaged in the practice of study of medicine since the date of such entry. This one you have to meet all 4 requirements. Very specific for special immigrant physician. Okay. And then we have special immigrant G4, international organization employee or family member, or NATO 6 employee or family member. So it says that you have to have a letter from the international organization demonstrating that that it is a qualifying organization and explaining the circumstances of qualifying employment and the immigration status held by the beneficiary, and for family members copies of evidence documenting the familial relationship to the employee. Okay, all that has to be met, those two requirements. And then we have armed forces member. You may file the petition for yourself if you have been served honorably on active duty in the U.S. Armed Forces after October 15, 1978. You were originally lawfully enlisted outside of the United States 12 years and you were never separated from such service, or 6 years and you are now on active duty and be enlisted to incur a total active duty service. So this one, either or, so you don't have to meet all those requirements. If you meet this one or you meet this one, for this one it's either this A or B. For number 2 it's either A or B. Okay, and then you come here, you are national, and then you meet this one as well and this one as well. You are a national of an independent state that maintains a treaty or agreement allowing national of that state to enlist in the U.S. Armed Force. So for this one, it's a lot that you have to meet in order to qualify for this. Okay, but just go ahead and check it out and see if you might be qualified. Then we have our famous one, that the one that everybody uses, the form I-360 for. That's the VAWA, self-petitioning spouse or child of a U.S. citizen or lawful permanent resident, or VAWA, self-petitioning parent of U.S. citizen, son or daughter. And when they talk about son or daughter, it can be adopted children or stepchildren as well included. Remember, with adopted children, child must have been adopted prior to turning 16. You must maybe live with the child at least for 2 years period of time. But that 2 years requirement can be there are a lot of presumption. You can overcome that requirement, but the before 16 really cannot be overcome. And then when it comes to adopted children, stepchildren, you have to be able to prove that you were married to that spouse prior to your child turning 18. So that's when the child will be considered a stepchild. Okay, so that's what I wanted to make a comment, because we've talked about VAWA in depth. Please refer back to my previous videos. So I just wanted to make that distinctions, because sometimes people say it's not my child, the child was adopted. You can still the child can still claim really under VAWA, provided that do it prior to turning 21. And if they don't do it prior to turning 21, they have us until 25, so basically to file, and provided that they can prove that the delay in filing was caused by the abuser. Okay, that's for VAWA. So VAWA is really, we talked about VAWA over and over. I don't want to really waste a lot of time for it, and that's the main one. Okay, and then we have Afghanistan or Iraq national supporting U.S. Armed Forces as a translator. If you are from Afghanistan or Iraq and you supported the U.S. Armed Forces as a translator, you could qualify as well, provided that you really meet all those requirements. So you are national of Afghanistan or Iraq, you work directly with the U.S. Armed Force or the chief of mission as a translator for a period of at least 12 months, like at least 1 year. You have obtained a favorable written recommendation, and before filing the petition, you were clear by a background check and screening. So that's what you can claim. And then Iraq national who was employed on behalf of the U.S. government in Iraq can use this form as well provided that you meet those requirements as well. Okay, you can go ahead and read it, but it's a pretty much straightforward requirement for that category as well. Okay, and each requirement, it gives you the document that you're supposed to file with. Okay, you must file this petition with those type of documents. Okay, so and then we have Afghan national who was employed by on behalf of the U.S. government or the international security assistance forces in Afghanistan. Okay, those are the requirements. Again, you have to meet in order to qualify, and then they give you really the type of documentation as well that you need. Okay, so then we have broadcasters like journalists. Then we have petitioning for unemployment based for preferences. Okay, it says that the petition for EB4 special immigrant, your employee must file this form 360. However, there are certain situations where you, the employee, may self-petition on your behalf. Okay, review the petition instruction to see if you're eligible to self-petition and what required documents that need to be included. Okay, so if you feel like you can self-petition on your EB4, please review that and let me know so we can find a way to do it. Because if you can self-petition, because sometimes the employer doesn't want to petition for you, but if you can self-petition, really try to do it, because you don't know, you might be qualified. Okay, so and that's for religious workers. Okay, so especially for religious worker, if you can self-petition, you meet those requirements of self-petitioning, you can use this form and you don't have to wait for the employer. Really check this thing out. Okay, I might have to talk about it just like a standalone subject. So that's it for today. I just wanted to go over this instruction. So, and then there's a fee for it as usual. So I just wanted to go over this instruction form because there's a lot to it. And some people really sometimes they only know this form for VAWA petitioning. But remember, you can petition if you qualify under those other categories. You don't really just have to wait for VAWA. Okay, that was it for today. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe, hit the notification bell, and don't forget to comment below. Share this video with your friends. This is very important. Go ahead and read it yourself. If you have questions, come down in the comment section and ask those questions, and we can see if we can figure out if we can help you out. And if you need a consultation with me, please do not hesitate to call my office. Okay, phone number is 202-751-2180. All information in the description box. Until next time, bye-bye.